I'm here with Carey Linde, and I'm really excited to talk to you. Carey is an attorney in British Columbia who has a really important case right now. And Carey, can you just tell us about it?
Yes, almost, but not quite a month ago, a mother came in to see me, and she advised that her 17-year-old daughter, with whom she'd been estranged for a couple of years, also with whom she had left her husband when the child was less than a year. And so and I say child only in the legal sense, this young woman, and my client, my soon to become client, advised that her intermittent meetings or being together with her daughter, just the most recent one, literally a day or two before that, she was told by her daughter that the daughter had been on testosterone for approximately 2 months by androgel, which is a pump cream that you rub on your skin. And if that wasn't a shock out of nowhere, and told her also that in about 10 days from that time, she was due to go into a surgeon and have a double mastectomy. So the 1-2 punch, I can only imagine. So so she retained me, and we spent a couple of days with her getting some information from her daughter, and me looking around, combining some nicknames and some names, and we determined who the doctors were. There was a general practicing doctor, just a GP, who practices in a transgender world, if I can call it that, and a cosmetic surgeon. So once we found out who they were, I prepared what we call a statement of civil claim, which is how you start a lawsuit in plain language, filed it in the Supreme Court Registry in Vancouver. It's the highest trial court in the province. And at the same time, or shortly thereafter, managed to get myself before a justice of the court on a without notice application seeking an injunction to stop the surgery. When I say without notice, in other words, we did it without notifying the surgeon that I was in court. And that is something which is only done or granted on an emergent basis. The justice, a woman, granted me the injunction. I wanted it to last until maybe Christmas or the new year, but she dated it to November 27th. Okay. So we then notified the 2 doctors, and the media, initially it was thought that if we could get away with it without the media circus that occurred last year, which was a circus in the sense that it wasn't the mainstream media. However, there's a mechanism within the court system that these kinds of notices of claim can come to the attention of the media, and phones rang and things. So I have kept the media somewhat informed as to what's happening because of their big interest. Now, I pause for a minute to say that the stories that have been coming out and the media attention is a great thing to see in terms of the complete lack of media, the total silence in the mainstream media that followed for all of the AB versus CD case, which you're familiar with. That case, the media that looked after that was blogospheres, social media, and what could be called the faith-based right. Nothing wrong with that. Um, so we now have some media attention. I was in court yesterday, which I will get to in a minute, and accused of launching a media campaign, and to which I took some effrontery, as if the media has no role to play, and as if keeping the Fourth Estate focused and putting a bit of light on some of this is a bad thing. And as for it being a campaign, I don't know what they mean by that. In any event, so what then happened was that at the beginning of the week, they brought the lawyers for the doctors. Now the doctors have insurance, and they won't have to pay. They've got a huge law firm, and they've got 2 lawyers on this, and who knows what staff. Similar lawyers, similar firm that was on for a doctor last year on the other case, and then 2 lawyers, one who represented the mother in the last case, and another lawyer who's active only in the gender area in Vancouver, announced that they were representing the young lady, the daughter. So
The daughter who wanted the mastectomy.
the one who, yes, who was extremely annoyed with her mother for having stopped it. So now we have 3 different law firms, one big one, one moderate, and I don't know the other one, sort of tag teaming my client in different directions, seeking all kinds of things at the same time. Anyway, yesterday we spent the whole day in front of a justice, and a male judge, because earlier in the week, the lawyers for the doctors had gone into court seeking what they call short leave, seeking permission to bring on an application in less than the standard 8 business days. And I consented to having it heard yesterday. And so that's what happened. And curiously, the lawyers were there representing Dr. who is the GP. And they were not representing, and Dr. McKee, the cosmetic surgeon, did not participate, which is curious in the sense that the injunction was against him, and money is no problem. But what they were after was they wanted an application, in essence, to anonymize the doctors, to remove their names from the public, to hide them from the public, to hide them from the media, on the basis that the doctor, in his affidavit, in her affidavit, stated that she was aware of other cases, namely ours from last year, the other case, where the practitioners who administer the steroids to these basically teenage girls had been protected because there were some threats. And it's important to remember or to state that a year ago, February, when my then father client, CD, had a 2-day hearing. At that hearing, by consent, it was agreed that he, his daughter, and the child's mother, all their names would be anonymized. And
Can I just interrupt you? Do I need to edit out daughter?
No, I mean, it was his daughter.
Okay, I wasn't sure because I remember when we did previous interviews that you weren't.
Well, you can if you wish. Perhaps maybe you would want to. I'm comfortable with it.
If you're okay with it. I just wasn't sure legally if you needed it.
But this is an interesting discussion that might stay, because no one is claiming that that child is now my father client's son. It certainly isn't being claimed that this person is is the son of my father. It's a daughter who prefers and has a reason to think that she is to be advantaged emotionally if she takes on all the attributes of a male. And I have no problem, using male pronouns or the male name. But here, when we're talking about the background facts,
Mm-hmm.
So when the two doctors asked to be anonymized a year ago, and Mr. Justice Bowden declined. So a couple of months later, they came back into court armed with affidavits with, what would be called sticks and stones will break my bones sort of stuff, plus one fairly serious threat. So they then became anonymized. And so it's clear that the doctors in this case, from our client, who is AM, they just thought that by right, they should be hidden. And the case centered, the hearing yesterday centered around the lawyer. There was two lawyers, but the one who spoke on behalf of the GP referenced judgments from last year's case, and went on and on and on and on. And when it was my turn, I simply stated that facts found to be facts in another unrelated case are inadmissible in any other case. All of that, the so-called findings of fact by the judge in the ABVCD case, they're all inadmissible. And I said that these counsel are serious, experienced counsel. They know that's the case. So why were they doing it? Well, clearly, there's only one reason to do that, and that's to sentimentalize the case, pull on the heartstrings of the judge, which they did extremely well a year ago in that other case. But it was all in, and I sort of wrapped it up by saying, because this particular defendant said that things could happen, might happen, possibly happen, remotely happen, feasibly happen. You can go on and on and on. There's no evidence. And to grant immunity on the basis of what might happen would mean that English common law, which covers England, Scotland, Wales, Canada, Australia, New Zealand, the United States, would have for the very first time ever a category of medical professionals for whom the law wouldn't apply, for whom there would be no way to put a flashlight on them and see what's going on, for whom they would be protected. And that is, I refer to that as, that is a radical change.
And what is the argument that this certain class of healthcare professional should be ascribed anonymity when no other group or individual is automatically assumed to have that privilege?
Well, in the ABVCD case, it was because a psychologist and an endocrinologist came forward demonstrating that they were the receivers of some nasty threats. And as I said to the judge yesterday, if you say that threats can warrant it, what degree of threat? I gave the example, if somebody walks out at night outside the doctor's house and yells up, "I don't know how you can sleep doing what you do." Is that a microaggression? Does that warrant the shutdown? I mean, sticks and stones will break my bones, but names will never hurt me. I mean, if you don't want to get shot at, don't join the army.
Well, and the interesting thing about this case is I've seen Dr. McKee. Is that the surgeon's name?
Yes.
Dr. McKee. I went to his website and I was shocked. He has picture after picture and video of young women and potentially girls who have had their breasts cut off, healthy, otherwise healthy girls who had their breasts removed due to a mental health issue. And my question is if doctors are actually doing harm to their patients, but are protected, they're anonymized, so they're protected. How do we call doctors out who are committing abuses against their patients?
You know, it's in the hands of that judge. And I do not know the extent to which the judge, I tried to educate him. I'm unfamiliar with the judge. He's only been on the bench for a little while. I don't know if he appreciates the enormity of what he might do if he goes in the direction that the doctor's lawyers want him to go.
Well, and
I
it,
should
it
also,
just to me, it's really, it is this question of, you know, some of the things that the doctors in the CD case were called was, they were compared to Joseph Mengele. They were called child abusers. And arguably, some people believe this to be true. And so does the judge in this case determine that those are threats and inappropriate, or does he determine that they need to be protected from this even if it's true? I mean, that's what I'm grappling at, is it seems like in
I
this
think,
case
yeah.
the judge gets to decide whether or not these medical professionals are in fact engaging in what could be considered abusive practices.
Well, I'll come around to that, but to go back to your point, the judge last year, Madam Justice Marzari, who made the order, is what could be called, in a judicial sense, a radical feminist, in the sense that she only came to the bench after being president of a women's feminist legal clinic, where she had been on the board for 10 years. So the litmus test to her probably was that somebody saying you're like Joseph Mengele would tip the scale, whereas a more rational, unbiased judge would say that calling somebody Joseph Mengele doesn't mean or wave even a shadow of a potential threat. I mean, so the example I used was the only area where, and I made the point that in Canada, there's no history of anybody in the gender business being so much as had a pie thrown in their face.
And that's important because this is an emotional, strong emotions on both sides. And I think if there was precedent that these doctors were actually at risk of physical harm, then that might be very different than just getting their feelings hurt.
Yeah, but also, you know, probably as you did, more people know about them who are interested by surfing the web. Because as you say, they're all over the place. You know, you have, there have been murders. A couple of abortion doctors have been murdered. However, even that class of medical expertise is not protected. If a woman comes into, files an action in court here against abortion Dr. Smith and alleges that abortion Dr. Smith botched it all up and did a whole bunch of weird stuff and or whatever, Dr. Smith does not automatically get protection. He's got to retain a lawyer. That lawyer's got to go into court and satisfy a judge that the facts warrant to hide behind a judicial veil. But to say that any doctor who does any kind of specialty is by automatic right protected is you know what it is? It's the social justice new definitions. It's like the very radical feminists who are trying to suggest to courts, very active in Canada and dead serious, that if a woman alleges a sexual assault, she must by right be believed, period. And that's the only way to solve this problem. That's the new definition of justice by the social justice warriors.
And there's a
This,
new definition of violence, which is something that hurts your feelings is now considered violence.
yeah.
And that's really concerning if we're going to provide people anonymity, or at least a certain class of people anonymity based on their feelings getting hurt.
Well, you may recall, I'm sure you do, that one of the orders that was made against my client, Father CD, that if he were ever to refer to the child who had been his daughter for 14 years with female pronouns or the child's given female name, that would constitute violence under abuse under the British Columbia Family Law Act. Now, in the Court of Appeal in January of this year, that was thrown out to the garbage where it belonged, and with some other things. But so now there's a pincer movement from the other lawyers against us because they want to bring an application to have the injunction against the surgery vacated, step aside, and they're in a mad panic rush to do that because, as in the case last year that had so many law firms, I mean, my client had turned around and sued the school board, the hospital, there was about 20 lawyers that went with. They got together and decided to move as quick and fast as they could and really make it impossible. So that's what's happening here. Applications are coming on fast and furious. And what I have to do is cause enough delay to permit the kind of investigation that the Court of Appeal in CD said. They laid it out very clearly. They said, this is what a parent has to do, okay? If the villain in the piece, they didn't use that word, is the Infants Act, which says under Section 17 that if a minor, somebody 18 or under, goes to a doctor, and in the one doctor's mind, what's being requested is in the best interest of the child, and the child is mature enough to understand it, they can do it.
And this is completely up to one doctor's determination.
And they don't tell the parents.
And that to me is just unbelievable.
Right. So what it's important for everybody in British Columbia and perhaps Canada to understand, and I don't know, I can't speak for the States, that when that occurs, the parent or guardian has a very narrow right to go to the court to look at the underlying protocols that were or weren't followed to determine not only how did they come to the conclusion that this was in the child's best interest, but more importantly, is it? Because as anybody who follows this knows, there is a huge gap between what all of these rapid onset dysphoria young girls decide because they've been on the internet with all of their girl buddies want to do, and they don't care if they never have a baby because they just want the testosterone. You know, that half of the formula is always a certainty. The other half, is it in their best interest, is where, as I said to the judge there, and I took them to the 166 different peer-reviewed articles against it, and made the comment that there aren't any that support the other side, because you can't peer review somebody's subjectivity. So there's
and we
there's
actually have really good research. There's a new study out, Brandstrom and Pachinkas, that show that people who get these kinds of interventions have higher rates of self-harm and higher rates of suicide after both cross-sex hormones and surgery. So there's actually now evidence showing these are harmful interventions. And so I'm trying to figure out how any doctor can justify providing a harmful intervention to a child.
Well, they can't, other than an ideological argument. And just to make it clear, those articles that you're talking about are in among the ones I mentioned. What I'm saying is that there's no scientific evidence that it does any good.
No.
And because particularly when you look and you say, okay, the suicide rate among these very tragic, unfortunate young girls is 19 times higher than the average, and that suicidality doesn't change after transition. So that can't be the goal. So, you know, this whole thing, and I'm not going to get into it here because my position is this: whatever an adult wants to do with their body and whatever they want to call themselves, that's fine. But whatever you want to call yourself, it's free speech. And everybody's free to say, I don't think so, or I disagree. So, oh no, you can't do that because that makes you a transphobe. But when it comes to the children, there are the two things which are the real problem. One are the schools which have no problem talking to a confused, probably emotional, and 20% are on the autistic spectrum. I mean, you've got a really, really weak, psychologically weak, hungry for identity population. And the next thing you know, too many of them are shepherded to a gender clinic, run into an endocrinologist who thinks that if you've got a problem and your mind doesn't think that your body is what you've done, oh, this will help you. But you don't do it with children when you're asking them to give up things that, you know, you ever want to have any babies? Doesn't bother me in the least. Do you ever want to be the best breastfeed your kid? Nope. I mean,
yeah, children really aren't capable of making those choices. And it begs the question, if a child went into a doctor and wanted some other kind of, like a lobotomy, just said, you know, I'm unhappy, I really am not handling life well, can you just give me a lobotomy? Would a doctor be able to do that? And would people stand by and say, oh yeah, that seems okay?
There is a very tricky difference. It's like Piers Morgan in England is going on and on. He's made it famous. Well, if I think I'm a penguin, I'm a penguin. And it makes trans people furious because it's apples and oranges. That's not the point. What we have here isn't just, I feel depressed and therefore I want a lobotomy. What we have here are kids who have been taught, campaigned against, proselytized, talked to their friends, that says that the solution to this and other problems, if you read about how girls get raped and abused and you think, well, I want to be a boy, or all the other reasons, or if you are a young boy who has some sense that maybe they're gay, but rather than face that, I think I'm a girl. Now, it's interesting that in India, being homosexual is really difficult to survive in. But they've got one of the freest and most widely open trans communities on the planet. So it's no, science, space science to suggest and to realize how many of the trans women just are having a happier life because they were hung up on being a gay man.
Well, and I've interviewed a number of detransition women, and the same thing, they're lesbians, and they were, they were given a hard time, or their parents weren't accepting, or they had internalized homophobia and decided, well, it'd be a little bit easier for me if I just say I'm a boy. But these are interventions that are harmful in the long run, that can cause irreversible damage to the body.
Oh,
And
absolutely. Yeah.
it's hard for me to understand, legally, how can doctors prescribe interventions that are harmful?
Because the medical professional governing bodies in British Columbia, the College of Physicians and Surgeons, are negligent and have dropped their oversight. They permit this to happen. But you mentioned detransitioners. That is a very interesting area in all of this. because it's almost laughable when a trans woman or a trans man, young or any age, could have been there for 20 years, decides to transition. The rationale, the response is, it comes back, well, they were never really trans.
Right. And it's interesting because a lot of times kids who have no history of behaving in a way that would suggest that they were gender dysphoric or body dysmorphic or had even gender nonconforming, when they say they're transgender, nobody says, well, you were never really, you used to be perfectly comfortable in your body. What happened? But when it goes the other way, people are very questioning and saying, wait a minute, you never really were trans in the first place. So it's sort of like, okay to go one way, but not the other, which I think is really telling because it suggests that this, as most of us know, this is an identity issue and not anything more than that. And our identities can change pretty regularly based on who we're around, what information we have, the kind of ways we want people to perceive us. And I don't know how we justify harmful interventions to confirm somebody's identity.
Well, we don't. And, and this, the child here, the young woman, um, according to my clients talking to me, only first even mentioned a gender-ish type issue when in school at the age of 15, where she came across what she thought was a girl and was a girlfriend who was a cis male. And so she talked like that. She never sort of let on that this is something she wanted to do. It was all just sort of a curiosity. Um, the other issue here is this young woman was born with an inheritable disease which affects a little bit of scoliosis, a little bit of body skin. It's not gigantism, but she's 6 feet 2 inches tall. And when I mentioned why a girl might want to become a boy, because of various reasons, it's not inconceivable. It's almost a guarantee that somewhere in her head, she says, if I was a 6'2" male, wow, would I be something? So to go back to the lawsuit, all that my client wants to do is find out if any of these questions were ever asked. Did the doctors who are doing this have any idea about all this? If they do, well, we're left with, it still isn't in the child's best interest. If they don't, if it was slipshod, then there's actions against them there in the sense of a complaint to their college, because they should, no damn way should they be able to do this just on a hunch. And what makes this one even a little more potentially weird is that the evidence of the young woman is that she met with the doctor once on Zoom. And it may be that there was one in person, but there may have been one in person, maybe not. But it was a fair number of these Zooms consultations. And on the basis of that, she's given a prescription to go and get the testosterone.
Without a psychological evaluation.
Well, we don't know, you
We
see.
don't know.
And what the British Columbia Court of Appeal said in its decision in ABVCD is that the only thing that a guardian can do is to go to court to see if they did do what you just asked. That's the limit within which they can do that. And of course, they do that for then having the right to argue that what's being proposed is not in the child's best interest. Now, in this case, I have no instructions to ask to cease the testosterone, because even if it's only been a couple of months, taking somebody off of steroids, anabolic steroids, is a tricky business. You have to do it slowly and gently, and you have to watch what's going on. So that kind of wraps up, it's a long speech, but that's what it's all about.
And it seems like fundamentally it's the Infants Act that is just a huge problem, because your client found out about her daughter's plans, but some parents may not find out
Oh
about their
yeah,
daughter's
early
plans,
on.
in
Yeah,
which case they have no option to litigate and to try to prevent this from happening.
every every jurisdiction has a statute which governs minors in the absence of guardians. In British Columbia, it's the Infants Act, which means that if uh, you know, 10 and 14-year-old brother and sister, their parents get killed in a car accident, and it wasn't their fault, the office of the public trustee by law steps in and is the guardian for those kids to sue. And what the Infants Act did in 1993, the then Social Democratic Party in British Columbia um, passed an amendment which authorized doctors, upon being asked by a young girl for something that a doctor thought was in the young girl's interest, and the young girl knew what it was all about, to do that. But when you read the transcripts of the debate in the Legislative Assembly, there was only for one purpose, and you can probably guess: birth control pills. Girls wanted to be able to have birth control pills, and don't let mommy and daddy know about it. It's clear that's what it was meant for, not for what we have now. Um, so I want to go back to the idea that, I've often, people say, I would say, if I thought I was Long John Silver, the pirate in Treasure Island, and I wanted to have one leg, and I went in and said, take this leg off at the knee, as an adult, I mean, there's some examples of that, I would be viewed with great suspicion, told to see a psychiatrist. But they don't do that when it comes to women who want to have their this or that removed, or their eggs sterilized. Um, so it's not as simple as simply saying, as Piers Morgan does, well, I'm going to call myself a penguin. You get trans racists, white women who have gone for years, decades, passing themselves off as black and running black organizations. Um,
Although in that case, when Rachel Denzel was found out, people scorned her and were not, people did not accept that she was black, even though she identified as black. And yet in this case, girls who have no history of identifying as anything but what they were
right.
born, who suddenly come to the conclusion that they want to identify that way, are embraced and celebrated, and
Yeah.
doctors are just enabling this self-harming behavior.
So just for the edification of your audience, in Great Britain and in northern Sweden, in northern Europe, 10 years ago, the ratio of boys to girls transitioning was 4 boys for every 1 girl. And in the last several years, that switched to an astronomical figure of 4,000 to 1. So if you're listening to this and you're unaware that this is happening, it is everywhere. It is huge. And there's a medical branch of the medical profession pushed along by big pharma. Yet the costs of having, if you have to pay for, or the insurance companies pay for having to have testosterone every day for the rest of your life, wow, there's a policy I'd buy into if I was a capitalist.
Yeah, and that's where we've noticed in the U.S. That there are clinics that are funded by a big pharma, and it's not surprising because they're going to get their money back in abundance.
I heard from a reliable source, I haven't checked it out, that testosterone for a year in some places can be up to $30,000. I find that outrageously expensive, and it probably isn't true. But
it could be true for puberty blockers, though. Puberty blockers are really expensive. So,
right.
so Carey, I'm trying to envision your case. You've got a mom, she's trying to prevent her daughter from getting her breasts removed. You've got doctors who are trying to make it so that the press cannot report their names publicly. You've got a hearing that's going to wrap up on Monday. Can you lay out the different trajectories of this case and how it might play out?
Well, it's important to understand that the young lady is 17 and a half. And in a year and a half, she'll be 19 and can do whatever she wants. The ABVCD case, which started almost 2 years ago, is still underway. And the child there has aged 2 years.
Yeah, she
And
started out
so,
at 14, I believe, on testosterone.
yeah, so a year, he's now 15. So he can, uh, that litigation, if it wanted to, but it's reached its end, other than, as you may know, the father there has been accused of breaching orders whereby he's given his name and done some various things. So the government, the state, and the Attorney General of British Columbia has hauling him up back into court, trying to
And
seek
that's because he spoke to the press, I believe, about
yeah.
things that the courts had determined would not be allowed to be talked about to the media.
That's what's alleged, and they're after him for criminal contempt, for which there's theoretically prison. So that's a whole thing which is going to probably happen in the new year. But going back to my client AM, if the judge orders a protection order on this doctor, a lot of people around, people that know about this, England, Australia, the others in the United States and Canada, are going to have to get together and say, okay, do we appeal this all the way up to the Supreme Court of Canada? What's that going to cost? If he leaves it the way it is, the cynic would say that the doctor's going to go out looking for insults and come back if he thinks he's got a ton of them, and do it later.
And yet the name's out there now. There isn't an injunction right now, so we can say their names now.
Yeah.
And so in a way, it seems almost like humoring the lawyers to grant this injunction.
Well, as I've said, and I repeat, the transgender movement, together with a lot of the other woke people, don't want to have public disclosure. They want to operate in the dark. For one reason is, if you cannot rationally argue with people who think that the basis of any discussion is that my facts can be different from your facts, and my definitions mean one thing and yours means something else. You can't talk. So there's no debate. There's absolutely zero discussion. Once in a rare while, I see some really interesting debate. It is fantastic when people can sit down and not yell and scream and start off with some definitions. I mean, there are real issues to be discussed in feminism, in racism, and all that stuff. But the way that the way the social justice warriors are doing it is absolute rubbish.
They just want
Absolute
to shut
rubbish.
down free speech, which to me is incredibly scary when
Yeah.
one group gets to dictate, first of all, what speech constitutes violence,
Yeah.
and secondly, who gets to speak and who doesn't, and thirdly, what class of people get protection and what class don't.
I want to put in a plug, I don't know whether you'll run it or not, for a book called Cynical Theory. It's the best book out on this. It's by Helen Pluckrose and
Uh,
James Lindsay of England.
yeah,
It's very hard to get. It's only been out. It took me a month to get mine. It's an absolute primer for anybody who wants to understand how this is going on.
And if you can't get the book, Google the videos, because James
Yeah,
Lindsay and Helen Puckross and
YouTube is
Peter
full of it.
Boghossian have done some important videos about how absurd things have gotten.
Yeah, and it can teach you what postmodernism means, how postmodernism fits in with social justice, how it all goes back to historically, how we got to where we are, and what it means. Yeah.
And it also talks, I think, about moral relativity and how we're not allowed to say that a doctor is abusing a child for giving them treatments that are harmful now, because that might hurt somebody's feelings, which to me, I
Yes.
honestly, I know that people have brought up the analogy of these doctors being like Joseph Mengele. And the question is, what would have happened if Joseph Mengele had gotten protection, had gotten anonymity? Because for whatever reason, he was getting threats and was having his feelings hurt. And at what point as a society can we say what a doctor's doing is in fact abusive and should be called out, and that doctor shouldn't be protected because what they're doing is wrong?
Right.
So I'm hoping I can follow up with you.
Well, okay. Well, I don't know if I've actually finished your point about where does this all
Oh
lead.
yeah, please
So,
continue.
so if the judge, as I said, dismisses the application, um, then we have to, I say we, my client and I have to uh, hustle to get the November 17th deadline on the injunction extended. That would have been done by now, but for the application of the law firm for the doctors tying me up all week to deal with what happened yesterday and will terminate Tuesday. So, well, I don't know how much you want to hear. There's been some very interesting phone calls have come into me and emails of support from all over the place. Some amazing stories. I may have forwarded one to you. One woman gave me permission to send out a long email and some stuff.
I don't think I saw that.
I'll have to, you know, put all this stuff together. I got a call from a young man, a man the other day, congratulating me, and sort of stroked my ego, how brave and all this stuff, on and on. So I said, oh, enough. Okay, wait a minute. Where you live? And he lives in a small town in the interior of British Columbia. And I said, well, why don't you go down to the local newspaper and because you obviously you've got good feelings and facts, and have them push this story. And he said, oh, I couldn't do that. My brother and I have a small business in this town, and we'd get, we would get canceled, basically. Now, that's coming from a very small interior resource-based town, and even they don't want to get involved.
Well, and to that point, you are brave, and I am very appreciative of your efforts for standing up for, for both CD and for your new client, because very few lawyers are willing to take these kinds of cases. We have very few people in general who are willing to speak up, because ironically, the doctors are concerned about being called names and such. But those of us who are standing up against the trans activists get outrageously horrible threats regularly. We are threatened with rape. We are threatened with murder just for speaking out about what we believe. And so it's interesting that in this case, there's a group that's kind of claiming to be at risk, and yet it's the group that's at risk that actually has more power. And those like you and I who are trying to challenge these things are oftentimes the ones who are more of a target for these.
Yeah. Let me tell you something funny. My last name is spelled Linde,
Uh-huh.
and it's properly pronounced Linda, not Linda, Linda. So all through my childhood, I was bullied by that girl's name, and sometimes it would really bug me, and after a while, there it is. And then I started going to school, and to this day, people send me mail, Mrs. or Miss Lind, and people always get my name wrong. And if someone did that, if someone came up to me publicly and said, "I'm going to call you Lind," and I know it bugs you, if this had to do with the trans people, I could go after them in a human rights tribunal and get money out of them. If I go up to a trans woman and say, "I'm going to call you him" on purpose, that's about $1,000 fine in this province and in this country. That is outrageous.
Well, and I think ultimately what is important is that we recognize that feelings do not override fundamental rights. And that's kind of where we're at, is that we're
or facts.
Or facts, right? That feelings do not replace facts. And and I'll be curious in your case, in the case that you have right now, because if you don't get the injunction and she goes ahead and has the surgery, it sounds like your case is probably over. I don't
Oh,
know if
no.
you know, so you
No,
can.
no, 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 no. You have to, I've got to make this clear. Given that this young woman's age, so let's just assume that the they can't be hidden. Well, or if they can be, it doesn't change anything really. Maybe we won't be able to keep the order, the injunction order, although I do have some ideas as to how I'm going to be able to, I am going to be able to do that. And then the girl, between me and a fence post, given that the Dr. McKee, the surgeon, didn't have counsel, it crosses my mind that in any event, even without any of this, just given the publicity, that doctor, either in his own conscience or by his insurance company, is saying, don't touch that girl. So
That
it's
would
a
be
question.
my hunch, because if he does go forward with this and his name is in the media, and it will get out,
And
even
if
if there's an
something goes
injunction,
wrong,
and if something goes wrong, or if at some point at a later date she regrets it, then he's going to really be facing a lot of scrutiny. And the fact that his website is so blatantly celebrating
yes.
these young women having their breasts removed, I think is likely to bring scrutiny on him that he does not want. So I think you're probably correct.
And you're also, I'm sure, familiar with this case in England, which is starting to go up through the higher courts,
The
where
Carabelle,
some desisted
yeah.
people are suing the government essentially for permitting that to happen to them.
Right. And that case has been heard, but a ruling hasn't come out yet, as far as I
Yeah.
know. That's Kira Bell, and she's suing Tavistock.
Yes.
And so there are a lot of cases sort of in the works right now, and they're so important. So
And there are
thank
cases.
you. Yeah.
There are cases in the United States, which aren't in Canada, by parents who are taking serious issue with former males being put on women's or girls' track teams and sports teams. That's being litigated.
And we have a case right now where a father whose 10-year-old son was diagnosed as being a transgender lesbian is fighting to get his son free from that, the clinic that he was going to.
And
And,
there's that father in Texas,
right, Jeff Younger, who's
younger. Um, there's yeah.
there's a number of cases. So I think that there's kind of been a critical mass where finally people are starting to question it. And I think the detransitioners have been a big help. And I think Abigail Schreier's book that recently came out,
Yes.
Irreversible Damage, has opened up a lot of people's eyes, because one of the things that happens over and over again to me when I start to speak about these issues is people say that doesn't happen. They just deny that it happens. And they think that I'm just making it up. And so it's important for these cases to move forward and to have press so that people understand that this really is happening.
There's so many things that you could fear that would happen, and that's the Infants Act.
Yeah, and
So
ultimately, it sounds like they need to clarify the scope
yeah,
of the Infants Act so that it really is doing what it was intended to do, rather than allowing doctors.
ideally, ideally, the government of British Columbia and anywhere else has to add rules, a set of legislative procedures. You cannot make that decision under the Infants Act until and unless you go through all of these various things. For instance, the societies where I think they have a little bit of understanding on whether somebody should transition, they demand, like in Europe, Northern Europe, 2 years of psychiatric care. Japan says you can't call yourself trans unless you've actually had bottom surgery. There are other countries who, with France, I think you just say that you've decided to change your gender and that's it. You just walk into the driver's motor vehicle branch and they'll change your driver's license on your say-so.
Yeah,
So,
it'll be, I think that all of these cases are going to be fascinating to watch progress. And I
yeah.
really appreciate your efforts here, Carey, and appreciate your willingness to share your case.
Well, at my age, I'm not learning a new language. I'm not learning how to play the piano, but the ends of my neurons are being put to the test here. So all I'm doing is postponing Alzheimer's.
Although you might feel a little bit crazy given the circumstances that you're fighting in.
No, I mean, it's taken a while, but I see the nonsense on the other side very clearly.
Yeah.
And because I'm a lawyer, I think I sort of have a duty to sort of take that nonsense and deconstruct it, uh, because of the privilege I have to be able to walk into before a judge, and say, don't listen to these folks. They don't know what they're talking about.
Well, I'm really glad that you're challenging your neurons and staving off Alzheimer's.
I hope so.
Yeah, no, I know.
What did you say your name was?
Yeah, exactly. Well, and one of these days I might pronounce your last name correctly because I think I still got it wrong.
Fine. That's fine.
So Carey Linde, is that
No,
right?
no,
Nope.
Linda.
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 Okay.
It's a Scandinavian E, which is pronounced
Linda. Okay. So
Linda, not A.
Linda.
Linda. There you are.
Linda. Okay.
Yeah.
Carey Linda, thank you so much for joining me. And I hope to follow up with you on this case and see where it ends up. And also, CD's case is coming up. His contempt charges are coming up soon, and it will be fascinating
Well,
where that ends up.
on the 14th of December, we're going in there, and I'm asking for the judge to recuse himself on
Okay.
the basis of bias, which is a very interesting argument because it's not so much just the bias of this judge, which is probably the least of them. It's two previous judges, including the Supreme Court, the Chief Justice of the Supreme Court, Hinkson, who this is little clip you should run someday, not whenever you wish. There was when our client father CD was the order made in February said that nobody can stop the hormone injections. Herb Dunton, the lawyer, spent a lot of time trying to get the evidence together, and finally we got endocrinology experts to say what would happen if you stopped it. So we went in about a month before the appeal. We went back into the Supreme Court before a judge seeking a stay or to hold off on that, and we wanted to do it quickly. So here's what happened. At the end of 1 week, I contacted the trial coordinator and said, we want a day in front of a judge next week, emergency. And she got back to me later in the afternoon and said that the Chief Justice has decided he will make himself available any day next week at 9 o'clock. So we all agreed on Thursday, which was the Thursday of the next week. Now, the immediately following Monday was the 12th, 13th, 14th. So on the 15th, we went to court at 9 o'clock, and in comes the Chief Justice. His name is Hinkson. And he said, I got the whole day, so let's go. All right. So we spent the day. Argument was made. Mr. Dunton made the argument that we should get a stay. At the conclusion of the day, the judge said, okay, everybody back here at 9 o'clock Monday morning, I'll give you my judgment. That was a Thursday afternoon. Friday rolls along. I go home Friday after school. I almost said after school. There's a lovely Freudian slip. After work. And I'll never forget, at 4:40, I open up an email from the Law Society of British Columbia, my governing body. And it says, attached, please find a letter of complaint against you.
Oh.
Okay. From, guess who?
The
Chief Justice.
Really?
And it was dated the 12th, the Monday. It was dated after he decided to take the case.
Wow.
Before he sat on it, and he never told anybody about it.
Wow.
That is so improper.
Yeah.
It's hard to imagine anything more improper for a judge to do. So I had the weekend, and my lawyer buddies and client, we all caucused, and Monday morning at 9 o'clock, Justice Hinkson comes in and sits down, and I'm up and I say, I have a point to make. I've got a motion that you recuse yourself. Okay, so we heard it. I had it well written out, and I basically said that I had the letter. I had it attached to an affidavit. I gave him the letter. The other parties, they saw what I was talking about, and I read it to him. And I read the letter from the Law Society to me that said, attached is a complaint against you. So the first thing I said was, you complained about CD's lawyer to the Law Society for a variety of alleged wrongdoings, which is all bullshit, excuse the language. Not all. There were some things, but they didn't. But the point being that my client had the right to know that you had animus of such a degree against his lawyer, and you didn't say it. He should have had this adjourned or been given time to get a new lawyer.
Yeah.
And I read the law. The law is very clear. You except in this case, it's almost impossible to prove bias in the mind of a judge. So
Yeah.
that's not the test. The test is if a reasonably intelligent man on the street, a woman on the street, were to become familiar with the facts of this case, would they have a reasonable held opinion that there is a good reason why the client might feel apprehend bias? But this case goes beyond that test. This is actual bias.
Yeah. Yeah. This is documented bias.
So he came down, he said, it's not a complaint. It was an inquiry. The Law Society said it was a complaint. Further, you made no argument before me. I have 2 pages of written argument. And I'm perfectly capable of separating any feelings I have towards you from your client. That's the test. You cannot say that. You can't do that. And so we appealed that. But because there'd been so many previous appeals and poor CD owes so much money on costs, the other side went to court, and the Court of Appeal gave them security for costs, which means we have to post $5,000 before that appeal can get heard. And we don't have that, of course. So that's just sort of sitting there waiting to who knows what.
Oh my gosh.
So that's one of the arguments I'm going to put front and center on the 15th as to why there should be this judge should recuse himself.
Yeah.
And if he does, and if in fact there's a finding that the interior justice system in that building, because of the Chief Justice's control, I mean, he's the one who put Mazzari on the case.
Right.
Right. He does all of that. He knows who's saying on what. Then the replacement should be a judge appointed from the Alberta bench by the Alberta Chief Justice. Now, that may seem extreme, but that happens. That is how in Canada, and I don't know about the States, a Chief Justice from one province would himself or herself appoint one of their judges to go into another province and sit in a court where the issue was the administration of justice.
Okay. Wow. Wow.
Don't hold your breath.
Yeah. Well, it sounds like you're going to be busy for a while.
Yes. Yeah.